Welcome to this presentation entitled Minority Labor Arbitrators, Issues that Arbitrators Face. I'm Howard T. Spence. I am an attorney and arbitrator. I principally practice in the state of Michigan, although I do arbitration on a nationwide basis. I'm also a certified circuit court mediator. I also do consulting work, and sometimes I work as an educator or trainer. I have taught at the college level in the MBA program at the University of Phoenix, where I have taught law courses in business law, employment law, discrimination law, and also courses in human resources management. I've also in the past served as an adjunct professor of law at the Thomas Cooley Law School located in Lansing, Michigan. My arbitration and mediation practice is performed through Black Gold Associates, LLC. This presentation series is dedicated with appreciation to the Honorable Harry T. Edwards, former Chief Judge of the D.C. Federal Circuit, and also to the Honorable A. Leon Higginbotham, Judge of the United States Court of Appeals for the Third Circuit. Prior to being appointed to serve on the Federal District Court Circuit, Judge Edwards taught at the University of Michigan Law School. I had the honor and the privilege of taking several labor law and employment law courses from Professor Edwards. Professor Edwards was also one of the very first successful black arbitrators who was on the panel for the American Arbitration Association and several other panels during the 1970s and 1980s. Judge Higginbotham was judge on the United States Court of Appeals, and I had the honor of meeting him and enjoying some of his presentations dealing with the topic of race and the law during a time when he was a visiting lecturer at the University of Michigan Law School, where I was a student. Special thanks are extended to Professor Floyd Weatherspoon of Capital University Law School and to Jeremy Williams, who is the Director of Employee Relations at Darden Restaurants, Inc. Professor Weatherspoon has regularly not only taught ADR courses at the Capital University Law School, he has also, on an annual basis, directed a symposium and conference which has had as its focus minority ADR in the United States. At that annual conference, many arbitrators and mediators from across the country have come for continuing education and to network and to learn how to enhance their ability to integrate into the ADR profession. Jeremy Williams is the Director of Employee Relations at Darden, Inc., and in that role he has been instrumental in encouraging minority arbitrators and mediators to obtain experience as mediators while sitting on cases which derived from some of the employee relations matters handled at Darden, Inc. This particular presentation today is part 2 of a 3-part presentation which has dealt with the topic of issues confronting arbitrators generally and minority arbitrators in particular. In part 2, I am going to present and discuss with you 2 topics or 2 issues which I think would be of interest generally to arbitrators as well as minority and female arbitrators. Those topics are when the arbitrator gets sued or dragged into court, and also the topic or issues dealing with business and operations for arbitrators. When the arbitrator gets sued, generally I think that we are all aware of the concept of judicial immunity, And to a certain extent, that concept of immunity is also applicable to arbitrators. Arbitrators serve in the role of adjudicators, and in most states they are held to be immune from civil liability for the acts that they perform as an arbitrator. Even though there is this concept of immunity for arbitrators existing, there still is the possibility that an arbitrator will end up as a defendant in a civil liability lawsuit in the courts. For that reason, many arbitrators will consider and obtain malpractice insurance for their arbitration practices. Since many arbitrators are also attorneys, sometimes the malpractice insurance is an add-on to the malpractice insurance policies which those arbitrators maintain for their legal practice. Even though there is immunity for arbitrators generally, no one wants to be in a situation where they are actually named as a defendant or sued in a lawsuit. Immunity may mean that eventually the arbitrator will be held not liable for a complaint which is lodged against him or her. However, as most of us already know, just because you win a lawsuit or get a case dismissed does not mean that you won't be faced with a complaint and that you won't have to realize considerable aggravation as well as legal defense expense during the time prior to the dismissal of the complaint or lawsuit against you. Malpractice insurance is therefore something that I would recommend each arbitrator consider, merely because the costs of defense and litigation can be so expensive, especially since so many arbitrators are part-time arbitrators. It really becomes occasionally a major consideration for the arbitrator to determine whether or not they want to actually purchase malpractice insurance or go uninsured and take a chance that no one will actually drag them into court. The purpose of malpractice insurance is to protect the arbitrator against legal defense expenses. Aside from arbitrators being subpoenaed, sometimes parties attempt to subpoena the arbitrator as a witness for post-hearing activity or judicial review. Some state arbitration laws prohibit or limit subpoenas issued to arbitrators and other ADR professionals. Arbitrators who are referred for work as arbitrators from associations or panels maintained by the American Arbitration Association, FINRA, or the Federal Mediation Conciliation Service are encouraged and required to advise those referring associations immediately of any subpoenas or lawsuits which are filed and served upon the arbitrator. Arbitrators are not licensed or regulated, generally. Associations have developed and published guidelines for arbitrator behavior or ethics. Misconduct or ethical lapses may result in removal of arbitrators from association panels. Demonstrated misconduct or ethical lapses can result in decisions and awards of arbitrators being vacated. An arbitrator misconduct may waive or abrogate any arbitrator immunity and leave an arbitrator vulnerable to lawsuits. So thus, the issue of the ethics for an arbitrator becomes one which is significant. Each arbitrator needs to conduct him or herself in a manner that would leave the arbitrator less likely to be the object of complaints from parties who appear before the arbitrator. The arbitrator must walk a balancing line in all situations in which the arbitrator is involved in the hearing process, and one of the fine lines or balancing acts that an arbitrator must consider is what behavior can the arbitrator actually become involved in which would not cross the line and become perhaps an ethical lapse or worse. Aside from the issue or the topics relating to the arbitrator being sued, we have the issues of what types of problems an arbitrator or a potential arbitrator will encounter while attempting to develop and maintain an arbitration or mediation practice. Not all issues which confront the arbitrator or aspiring arbitrator relate to the actual conduct of the hearing. An arbitrator is not just an adjudicator. An arbitrator is also a business owner and a professional. Getting paid. Again, arbitration is a business or a career. It's not a philanthropic adventure. The referring association chooses the clients for the arbitrator, and sometimes the association will also help the arbitrator collect his fee from the parties who are referred to the arbitrator for hearing. Even though the associations will often provide a mechanism for the arbitrator to assess and collect fees, it's very clear, and the associations make it known to the arbitrators, that the arbitrators are not employees of these associations, and that while they serve on the panels which are referred out by these associations, the arbitrators themselves are independent contractors, and they are therefore responsible for collecting any unpaid fees which they may encounter during their arbitration practice. As I indicated before, many arbitrators do not maintain full-time arbitration practices. Arbitrators are often involved in related professions. Many are attorneys, some are in academia, some hold other types of regular occupation or jobs to supplement their part-time arbitration practices. The expenses and business concerns and pressures related to that business may impose additional concerns and pressures on the part-time arbitrator as a practitioner. Arbitrators who engage in an arbitration practice for a living have to be aware of some of the economic or financial issues that they will confront on perhaps a daily basis. There are, in fact, not only income issues, there are also outgo issues or expense issues. Many arbitrators will encounter what I call upfront costs related to their arbitration work. Some of those upfront costs are costs for the education and training which is necessary to meet the entry requirements into the profession. There are ongoing application fees and panel costs associated with the business of arbitration. There are also costs associated with getting the necessary experience to earn a place or be appointed to some of these association panels. Certainly there are office maintenance costs and networking costs which an arbitrator will encounter. And there also are travel expenses. Sometimes these travel expenses can be significant, especially if the arbitrator takes assignments which are remote or at a distance from the arbitrator's residence or primary place of business. Financial considerations related to providing arbitration services. Again, there are these annual panel maintenance fees which some associations assess and charge for the arbitrators on their panels. For example, the American Arbitration Association regularly charges approximately $400 a year for arbitrators who remain active and on their panels. In addition to that, there also is continuing education expense. Some panels make it mandatory that arbitrators assigned to those panels become involved in a certain amount of continuing arbitration education or continuing legal education. Arbitrators who are attorneys will often find that the arbitration continuing education will also be related to their attorney continuing legal education. And then again, there also are what I characterize as normal business expenses related to maintaining a practice. Additionally, I think I already alluded to the fact that a financial consideration would be the collection of fees, and especially the collection of unpaid fees which have been billed. Issues arise relating to financial considerations in all sorts of ways. For example, what if only one party is actually paying the billings for fees which the arbitrator presents in a timely manner? The logistics of the arbitration process: where, when, how will the arbitration be held? Will there be pre-hearing conferences? And if so, would they be telephonic? What about the processing and collecting of payments for fees and expenses? Will there be a transcript, a voice recorder, or note-taking necessary to develop a record in any particular arbitration hearing or process? Typically, arbitrators have the assistance of the referring associations, the American Arbitration Association, FINRA, FMCS. These associations will provide a mechanism for claimants or parties to come to that particular association seeking the referral or recommendation of arbitrators. Those associations also will provide case management services, and often there will be an individual at each of those associations responsible for interfacing with the parties and serving as an intermediary with the arbitrator outside of the hearing process. Those case managers will often be responsible for pre-hearing conferences, although depending on the nature of the case, the arbitrator will need to participate in those pre-hearing conferences. Those pre-hearing conferences are more often handled by the case managers at the associations for labor arbitrations, for example. However, where there is a need for the arbitrator to become involved in a pre-hearing conference, the issue arises as to whether that conference would be a face-to-face conference or a telephonic conference. It's been my experience that in most cases, the conferences which are held are actually telephonic. It doesn't make a lot of economic sense for an arbitrator to meet face-to-face with parties at a remote location for a pre-hearing conference which might only last a half an hour to an hour and a half. As far as the development of the record, this can be a significant issue. I think that we all have seen those situations where there is an arbitrator sitting at the head of the table, and while a party is testifying, the arbitrator is busily writing notes on a yellow notepad. I myself am not a very good note taker. I don't write very fast. When I am involved in arbitration hearings, I encourage the parties, especially if the arbitration is going to last more than a few hours or more than one day, to secure a court reporter. I, as an administrative law judge in the past, have learned the value of a transcript, which allows me to review the testimony and the arguments of the parties subsequent to the close of the evidentiary hearing. There is, of course, some additional expense involved in utilizing a court reporter, but if the arbitration case is significant, I have had some success in encouraging the parties to actually retain the services of a court reporter. The parties would pay for that court reporter and provide me as the arbitrator with a copy of the transcript. And that is very useful to me when and if I get involved in note-taking. I always have the concern that while I am busy scribbling on a notepad, I also have to be listening to the testimony and observing the witnesses and parties around the table, and that can be challenging. I'm sure that many arbitrators who only utilize note-taking miss a lot of the information which is actually offered in a hearing and which occurs around the arbitration table during the time that the arbitrator is busy writing. If there is not a court reporter and a transcript, I think that a second best option would be for the arbitrator to purchase and utilize a voice recorder or tape recorder and to record the entire proceeding. That would at least provide the arbitrator with a backup to his own memory of what transpired at the hearing, and it's generally more effective than note-taking by the arbitrator. However, it also has a drawback and an expense factor in that an arbitrator who relies on a tape recorder or a voice recorder will often have to play back the transcript, recording rather, of the proceeding after the evidentiary hearing is closed. That would add to the study time or the time needed by the arbitrator to perform the duties that the arbitrator has to write a decision following the hearing. Hearing location. Most locations are provided by the parties. If a hearing is held near an association office, then sometimes the parties will be able to actually have the arbitration held at the facilities of the association. I know that the American Arbitration Association in those cities in the region will provide for a fee actual hearing rooms for the arbitrations. However, those hearing rooms are often not utilized because the parties to the arbitration, the witnesses to the arbitration, are actually not in the immediate vicinity where those association conference rooms are available. Sometimes the parties will have the hearings held at the local business or the employer. At other times, the parties will reserve a room at a hotel or at some location which is mutually acceptable to the arbitrators, and of course the parties will pay any rental expense associated with that particular arbitration conference room. Some arbitrators, especially arbitrators who are affiliated with a law practice, will have a conference room or facility available at their own office, which they can offer to the parties, and of course that is very convenient to the arbitrator if the parties agree that the arbitration would be held in the arbitrator's conference room. I myself maintain a conference room in my home office, which you see here. However, this particular conference room is seldom used by me for the arbitrations, just because sometimes there are more parties and personnel involved in the hearing than can be accommodated in my conference room, which is basically set up for 10 people. And also, most of the time, it is a significant inconvenience to the hearing process for the process to be held at a location which is remote from where the parties actually are. That's especially true if there are a significant number of witnesses who will need to testify. But the hearing location is a logistics issue that has to be considered. I would suggest that most arbitrators, especially part-time arbitrators, do not need to actually maintain a facility for these arbitration hearings, but should rely on either the association or the parties to secure a location. The Arbitration Association or agency as a service bureau. Many arbitrators do not maintain full-time clerical support staff. Instead, those arbitrators would either be responsible to use their own part-time staff or to use service bureau staff that might be available to help them with the publication of the decisions and opinions which those arbitrators generate. Most arbitrators utilize the association agency as a service bureau. The major associations provide case management services. Those case management services include being available for the parties to approach seeking the appointment of an arbitrator, and the case manager assigned by these associations also will receive the pleadings, the claims and complaints of the parties, and would forward those materials onto the arbitrator at the appropriate time during the process. The claims managers also will serve as an interface between the arbitrator and the parties so that the arbitrator does not need to run the risk of being involved in ex parte communication outside of the hearing process. The American Arbitration Association, apparently realizing that many arbitrators would need and benefit from case management services even where the American Arbitration Association was not itself providing full case management services to the parties, has recently instituted what I call light administrative services. These light administrative services provide for a fee which is charged to the arbitrator rather than the parties some of the basic case management services, including scheduling assistance, processing of documents, and also the transmittal of decisions to the parties following the completion of the case. It's noteworthy that in most cases the case management services which are provided by an association are actually paid for by the parties, and those case management services are included as a part of the fee which the parties will pay to the association at the time that the arbitration process is initiated and a claim is filed. I spoke briefly a bit earlier about the need to develop a record during the arbitration process when we talked about whether or not a court reporter should be retained. In most situations, the arbitrator is responsible for retaining and maintaining the arbitration record which is developed. Arbitration records may be required if there is an appeal of the arbitration decision. The records which are sent to the arbitrator are the responsibility of the arbitrator. The arbitrator also will collect any exhibits which are actually offered and accepted into the record during the course of the proceeding. I've been involved in some multi-day arbitrations where a complete lateral file drawer is full of the record of the arbitration. That record would consist of exhibit books which the parties may prepare and submit to me as an arbitrator. It would also consist of the claim and any documentation which is filed directly with the association or the case manager, and that record also would consist of any pleadings which are submitted to me in the way of either motions, briefs, etc. These are things that become a part of the record, and at some point the arbitrator has the responsibility of maintaining that record. Generally, there is no rule which indicates how long the record must be kept by the arbitrator. I think that it is prudent to retain records at least for the amount of time which is allowed for any appeal of the arbitration decision to be taken by one or both of the parties. That would vary from jurisdiction to jurisdiction. The time limits for appeal of arbitration cases may also be codified and included in the rules of the association, which may have been adopted by the parties at the time that the arbitration decision was issued. Another topic or issue which generally is raised in conjunction with the topic of the operation of the arbitration business is generally the concept of diversity in ADR. You may recognize that is the actual overall topic of this particular presentation series. A number of questions are raised within that particular issue. One question is diversity actually a legitimate and or worthwhile goal in the arbitration process? Another question which is raised is who should be responsible for increasing diversity within the ADR profession? Another question which an arbitrator should consider would be the question of should the associations take affirmative steps to assure that the lists of arbitrators which are referred out to clients or potential parties, should those lists routinely contain the names of minorities and females? And finally, there is the issue of what strategies are appropriate or possibly helpful for encouraging parties to begin to request and select minority and female neutrals more frequently. Now, I began this presentation with the premise that diversity in ADR is a desirable objective. I personally believe and would prefer to see diversity not only in the arbitration profession, but also diversity in education, diversity in the workplace. Diversity, I think, in terms of my own viewpoint of the world, is a desirable objective. However, I think it also is necessary to acknowledge the fact that there are some individuals, including some arbitrators, who may not be as convinced as I am that diversity is a legitimate goal for the ADR profession or for arbitration. And I think that we need to be mindful of that reservation that some individuals show about diversity. That reservation is especially obvious sometimes when the issue arises as to whether or not there should be an affirmative step taken to encourage the entry of minorities and females into a profession. Historically, the arbitration profession has been a profession which has been dominated mostly by white males, and over time those white males have tended to become older white males. And while there is certainly a large number of those persons who have been in the profession for some extended period of time who would favor the enhancement of diversity in the profession, we need to also understand that there are some individuals who have impact on the profession of arbitration who would argue that the goals of arbitration to provide neutrals who issue fair and meaningful decisions has already historically been accomplished without this infusion of diversity into the profession. And so there are individuals who are presently arbitrators who have reservations about the need for enhanced diversity. And there certainly are parties who have reservations about having their cases heard by minorities and females. And we're going to talk more about those reservations during the course of this presentation series. As far as strategies for encouraging parties to begin to request and select minority and female neutrals more frequently, I think that a large part of the responsibility for movement toward encouraging these parties must reside with the associations or agencies who are in the environment offering their services to provide arbitrators to individuals and companies that need those types of services. For example, the American Arbitration Association, FINRA, the Federal Mediation Conciliation Service. These particular associations and similar smaller associations certainly have a prime opportunity to enhance diversity in the arbitration profession by encouraging minorities and females to apply for and be accepted onto their arbitration panels. I think that each of the organizations or associations which I mentioned have articulated positions where they support increase in diversity within this arbitration profession, and with that particular mindset and attitude in these organizations or associations, perhaps the diversity which I advocate for this profession will soon occur. Another topic which I want to raise as a part of the considerations for an individual who is in the business of arbitration deals with the concept of professionalism. I believe that arbitrators should demonstrate professionalism, arbitrators generally, and this can particularly be an issue for minorities and females who are in the profession or attempting to get into the profession. The professionalism which is demonstrated should be in their education. Arbitrators and aspiring arbitrators should be well educated. Many of them today are in fact receiving postgraduate education as attorneys or in labor-industrial relation programs where they have tracks designed to provide education to individuals who want to go into the arbitration profession. The arbitrators should demonstrate professionalism in continuing education. They should work toward enhanced professionalism by networking with individuals who are colleagues in this profession, or also networking with individuals who can provide the access to the parties who utilize services for arbitrators and other ADR professionals. They can demonstrate professionalism by showing maturity, by being reliable, by showing integrity and honesty, and by having a judicial temperament and deportment. Now, in terms of maturity, most arbitrators, and indeed most judges or adjudicators, tend to be a bit older, and sometimes that age is an indicator of enhanced maturity. Parties expect and require maturity of the individuals who hear and adjudicate the cases and claims which those parties bring to the table. And certainly in any profession, reliability is important. While arbitrators are human beings and they all have some aspect of their own character or life which reflects that humanity, still, in order to be successful in this profession of arbitration, it is necessary that the parties are able to respect the arbitrator, and that reflects the arbitrator needing to exude or at least bring forth an appearance of integrity and honesty. Judicial temperament and deportment are crucial for a person in terms of demonstrating professionalism to either become or be successful as an arbitrator. And in fact, some of the associations in their literature where they discuss how an individual can become a member of the arbitration profession emphasize the fact that there is a significant need for a judicial temperament and deportment among candidates to become arbitrators. Prompt and fair decisions. Timeliness reflects upon professionalism. The arbitrator has a responsibility for managing a workload in a manner that would assure timely completion of cases and decisions. The decision of the arbitrator actually should be the decision of the arbitrator alone. The question arises as to when and to what extent it is appropriate for an arbitrator to get advice on issues from colleagues or others. Now, in terms of timeliness, timeliness is so important in part because many times the rules of the association or even statutes which are enacted within some of the jurisdictions or states require that timeliness occur. I think that the rules, for example, of the American Arbitration Association indicate that the jurisdiction of the arbitrator ends or is lost 30 days after the hearing itself is concluded or the closing written statements related to the hearing are received. That is a very significant occurrence and requirement. If an arbitrator does not get a decision written within 30 days of the close of the hearing and loses jurisdiction, all sorts of problematic issues arise, and the parties may even be able to reject the decision which is issued or offered by an arbitrator late. Suffice that an arbitrator who fails to meet a timeline for completion of a decision runs the risk of not receiving any future arbitration work, and in fact some of the associations will use that particular tardiness as the basis for removing an arbitrator from a panel and no longer utilizing the services of that arbitrator. The decision of the arbitrator should be the decision of the arbitrator alone. Now, in large practices where there is a heavy volume of work to be done, either in law offices or in arbitration practices, it is not completely unknown for an arbitrator or an attorney to have one of the colleagues or associates actually do the writing of a decision. I think that particular occurrence is very rare in the arbitration profession or practice itself. This particular type of situation is similar to a circuit court judge asking a law clerk to write a decision. Certainly the judge, or if it's an arbitrator, the arbitrator who delegates the responsibility for writing that decision to a colleague or an associate would give some sort of direction in terms of how the case would resolve itself and what evidence would need to be considered and discussed. I think that out of fairness to the parties expect that the decision which actually is ultimately delivered to them is written by the same person who sat on the case, who heard the evidence, and who signed the decision. While there may be some difference of opinion among some arbitrators, especially those who have large practices and are busy, I think that it is fairly safe to say that the arbitrator who sat on the case and who got compensated should actually be the one who wrote the decision and who signed the decision or the award. In terms of interaction with colleagues. I think it's very common, and probably we're all guilty of discussing with our colleagues or associates some of the issues which we confront, which may not be specific to one particular case. We go to organizations such as the Labor Employment Relations Association, dinner meetings, symposiums, and we all like to discuss war stories or situations we've encountered and bounce those off our colleagues. And I think that by and large that is an acceptable and perhaps even a necessary practice as a part of the ongoing or continuing education that we as arbitrators seek and require. Getting on panels. In order to be a successful arbitrator by and large, unless you are extremely well known in your own right, it's necessary to be actually associated on a panel where your name can be referred out to potential clients or parties on a regular basis. The problem arises that vacancies on panels have become fewer and farther between in the recent past. It's not unusual for panels to actually have no vacancies. Now, it's generally acknowledged within the ADR profession by the associations or agencies themselves that minorities and women are not represented in number on their panels as arbitrators to the extent that they either could be or should be. I need to take a moment to discuss the fact that the standards for becoming an arbitrator have changed over the years. The standards to be associated with a panel today are in many cases extremely high when compared to what the standards may have been 20 years ago. Many successful arbitrators on panels today got admitted or accepted onto those panels during times when the requirements for being placed on those association panels was less. And so today, individuals who are being added to panels by and large quite often are better qualified, at least on paper, than some of the older arbitrators who have been around for some time. Associations are businesses with profit orientation sometimes, and they work very hard to make sure that the clients or customers or parties that they want to represent actually have an assortment of arbitrators to choose from who will be selected by those clients. It's hard to get on panels today, and I think that many of the people who aspire to get on those panels and who are perhaps watching this video presentation have already recognized that. I think that the associations themselves are generally pretty open and honest when it comes to acknowledging the difficulty of getting on their panels. What you see on this slide is a representation or statement by the American Arbitration Association, for example, which appears on their website. It's pretty self-evident. AAA is the nation's leading provider of alternate dispute resolution services, and they are frank and honest to indicate that opens on their regional rosters for neutrals are extremely limited, based primarily on caseload needs and user preferences. And that final sentence, I think, is key to understanding the difficulty of getting on some of these panels today. The association states, consequently, even candidates with strong credentials may not be added to our roster. Now, I think that in terms of the issue of qualification criteria for admission to association panels, the fact that it's difficult to get on those panels due to enhanced or increasing admission criteria is obvious, but that begs the question, or raises the question perhaps, of what the panels would do in light of that particular situation to assure that the panels that they offer to potential customers in fact are diverse. Another issue or topic which I would raise for consideration is the fact that competition within this profession actually sometimes works against diversity. There are, in fact, a significant number of minorities who are already in the arbitration ranks, but sometimes these minorities or females hesitate to give newbies assistance with getting into the profession. Many established arbitrators are too busy to contribute time and effort to mentor or assist minorities and females seeking to enter the profession. And there apparently is fear by those who are already in that recommending or being associated with someone who is not stellar will adversely impact upon the professional reputation of those individuals who are in. Now, overall, the phenomenon or issue which I am talking about here reflects the situation which minorities sometimes recognize, where individuals who are successful of escaping from the inner city and getting to the suburbs quickly forget about the situation and needs of those individuals who have remained in the inner city. In other words, some minorities who have in the past struggled to become accepted into the arbitration profession do not seem to have great interest in encouraging other minorities or females to get into this profession. And sometimes that is an economic factor. To be honest, some individual minority arbitrators, for example, may get some of their business based on the fact that they are minorities. And as I've indicated in other presentations which I have completed and posted, there are in fact concerns raised regularly that there may not be enough work to go around, enough arbitrations to conduct for the number of arbitrators who are already in this business. I think the Bureau of Labor Statistics indicates that there are perhaps about 10,000 individuals who are involved in alternate dispute resolution professions, and a significant number of those individuals are arbitrators. And statistics which are published by government organizations, for example the Federal Mediation Conciliation Service, indicate that the actual number of arbitrations which are available for referral may not be so great that arbitrators have more work than they can handle. I think in the earlier slide in this presentation, where I referenced the American Arbitration Association statement about the need for additional arbitrators being less and the standards being higher, the whole issue is raised about whether or not this arbitration industry or profession is growing to reflect the demand for services of arbitrators. Another aspect of the fact is that some arbitrators, those who are successful and could mentor, are actually too busy to do it. It might take a significant amount of time and effort to mentor or assist individuals into getting into the profession. However, the way admission criteria for the arbitration profession are set up and have developed over time pretty much requires that the newbie or person aspiring to become an arbitrator gain some experience before the arbitrators can actually get on panels where they can hope to be referred out on a more regular basis. The third bullet point on this slide in this video, which I have discussed, also reflects what I see as perhaps a legitimate concern by some arbitrators, that someone who is not stellar is someone they may not want to recommend, because if the person does not perform at a very high level, then that may adversely impact upon the professional reputation of the individual who has recommended or mentored an individual. Okay, at this point I'd like to turn our attention to the topic of parties misusing the arbitration process. And this is something that we see, in my opinion, to some considerable degree. In terms of how parties misuse the arbitration process, one thing that one will see is one party or the other party or both parties filing what I would characterize as motions without merit. And sometimes those motions are filed to drive up the arbitration costs and the frustration level of opposing parties. We also see in the arbitration process occasionally what I would suggest is an unreasonable discovery demand, or on the other side of the coin, parties to the arbitration failing to cooperate to provide the discovery or information that has been ordered. Another situation which I would also characterize as a misuse of the arbitration process is the poor preparation of witnesses. And finally, one type of abuse of the process which I suggest occasionally occurs is the situation where the union and an employer apparently go through the process of putting on what I would characterize as a sham arbitration proceeding. Now, in terms of the filing of meritless motions, certainly the parties have a right to file motions when they think it appropriate, and I would encourage filing of motions if by filing those motions the arbitration process itself could be streamlined or cut down to size. The problem with meritless motions, as I've indicated, is that they have a tendency to slow down the process, and while I don't mind as an arbitrator ruling on motions, I certainly would hope that those motions are brought forth in good faith. As far as discovery goes, one of the supposed benefits of arbitration is that it is a less formal proceeding than the parties would be facing if they had taken their dispute to litigation in the courts. By the expansion of discovery, sometimes these arbitration hearings or proceedings actually become as complex and sometimes even more complex than civil litigation in the courts, and I think that is counterproductive to the process and also to the expectations of individuals and parties that enter into arbitration settings. As far as failing to cooperate with discovery, it has evolved over time that some of the demands for discovery are just totally unreasonable. We certainly want parties to be able to have the evidence that is available that would help them either prove their case or show that the position taken by the opposition is itself not with any merit, but just to go on broad fishing exploration operations and call it discovery is in fact, I think, counterproductive. Certainly it runs up the expense for the parties, and it delays the process. And as an arbitrator, I have to confess I would prefer that these matters move quickly down the pike so that I can make a decision if I'm going to make a decision and then move on to the next case. Poor preparation of witnesses. This is not a situation that is peculiar to arbitration. You see this in any type of contested case hearing process, including in the courts. And to a certain extent, while it is an abuse of the arbitration process, it's going to happen, especially if the advocates don't bring their A game and don't enter into preparation for these hearings in good faith. Union and employer putting on sham proceedings. This is something that can occasionally be troubling, but it's something that you occasionally see. Sometimes one party or the other is not particularly enthusiastic about the position that they're advocating in arbitration. Perhaps a union is bringing a grievance to arbitration, not so much because they believe in the merits of the grievance, but perhaps because of political considerations within the union membership itself. Sometimes you'll bring a grievance for a particular member which you might not bring for another member in the union. And along the same line, sometimes an employer will take a matter to arbitration just because someone in management has decided that this is a matter of principle, and the advocate for the employer may not see this particular situation or arbitration as the most appropriate opportunity to try that particular proposition and to get a decision which could be binding on the employer at some point into the future. One of my pet peeves deals with what I characterize as scheduling abuses of the arbitrator's time. The reality is that many scheduled arbitrations never actually go to hearing. Arbitrators cannot overbook hearings or double schedule. Sometimes you see in the judiciary or in the court systems, judges will schedule 2, 3, 4 trials all scheduled to begin at the same time. And that is a legitimate scheduling situation in the courts, because the reality is that just like in arbitrations, many times matters scheduled for hearing don't actually go to hearing. And so rather than have the courtroom empty and the judges without anything to do for extended periods of time, the judges, the courts will double schedule, overbook. They'll have several cases scheduled to begin on the same day, and they'll adjust the schedule as necessary during the course of that week so that the matters can all be heard, or at least most of the matters can be heard. Some parties use the arbitration process merely as an incentive to force settlements. The parties have an opportunity to negotiate settlements even prior to making the demand or claim for arbitration, of course, and sometimes they will even go into mediation before arbitration in an attempt to work out their dispute and save the cost, time, aggravation of a contested case hearing in arbitration. However, if they don't resolve their dispute in a timely manner, quite often you'll see them schedule this particular dispute for arbitration. You would think that they would try to avoid that, because usually when they schedule these arbitrations, the associations or agencies that schedule these arbitrations demand and receive what could be a significant case fee just for the filing. But in any case, these matters get filed, the parties select an arbitrator, the arbitrator and the parties get together for a pre-hearing conference, and the matter is scheduled for hearing at some point into the future. Actually, it's difficult to schedule arbitrations many times, because what you're looking at is finding a time when the arbitrator has an open space in his scheduling, and when the advocates for the parties also can schedule time for a hearing. And furthermore, you have to schedule the hearing for a time when your witnesses are available on both sides, and that can become a logistics nightmare in and of itself. So it's very typical during the pre-arbitration or pre-hearing conference to schedule these arbitration hearings several months out into the future. Again, my bias is let's get it over with as quickly as possible, but when you're doing the scheduling, you also have to allow time for the parties to do whatever discovery they may want to do prior to the arbitration time. And so with the necessity of the parties having time to prepare for the hearing, to do their discovery, and then coordinating schedules, parties, witnesses, advocates, and the arbitrator, you're usually looking at a matter of at least a few months. And during that time, quite often the parties may continue to do their negotiations toward settlement, which is fine. But sometimes the situation arises where the parties don't really get serious about negotiating resolutions or looking at the matter until right before the time that they have agreed would be the start of the arbitration hearing process. An arbitrator's scheduled hearing time is often wasted. Now, if we have scheduled this matter several months out into the future, one of the first things that becomes a consideration is you want to schedule enough time so that you will have plenty of opportunity to actually complete the hearing during the scheduled time. It's certainly counterproductive and frustrating to schedule a matter 3 or 4 months out into the future, schedule it for one day, and then suddenly find out it's a 3-day hearing, because what that means is that you are almost right back in a situation of having to find a second set of days when the parties can all get together for the continuation of the hearing. So during the pre-hearing process, the arbitrator or the case manager, if they are handling a case for the pre-hearing part of the case for the arbitrator, will ask the parties, how long do you think this hearing will last? How many days will you need for your case? And it's not unusual in that circumstance for the advocates to say, we need 3 days, we need 4 days. And again, what you're looking at is the possibility that they have been over optimistic in terms of how quickly they can conclude the hearing, and they're actually going to need more time than they suggest, or in the alternative, they may have indicated they're going to need a considerable amount of time, but when it actually gets to the point where the rubber meets the road and you're actually conducting a hearing, instead of a 5-day hearing, you may only have a 1-day hearing. So those are some of the situations that contribute to and lead to an arbitrator's scheduled hearing time often being wasted. Now, you have to understand that arbitrators, just like with attorneys, their stock in trade is time, and they only have so much of it. And even if the arbitrator is not busy, no arbitrator really wants to schedule a block of time where he cannot make commitments for other work and other possibilities for earning just to have that time canceled. So it's not unusual for arbitrators to write in provisions into their compensation contracts for hearing cancellation fees. I myself, in my compensation requirements, I do enter into and require hearing cancellation fees. Now, certainly you have to be reasonable with the cancellation fees that you require or impose, but all in all, the impending hearing dates and the possibility of the penalty of hearing cancellation fees, those things work together to cause the parties to attempt to become serious about settlement negotiations, hopefully a considerable time prior to the actual scheduled commencement of the arbitration hearing. Now, my hearing cancellation fees, I don't impose any cancellation fees if the parties settle the matter or cancel the hearing 30 days or more prior to the scheduled hearing date. That's fine. In 30 days I can probably find something else to fill that block of time and to make some money. If the parties don't cancel more than 30 days out, but do cancel at least a week or so out, then I still will impose a relatively minor cancellation fee, just sort of as a penalty or compensation nod for myself, because I held that time open, and quite often I did some preliminary work in anticipation of the hearing. The cancellation fee, if it's more than a week out, might only be $200 or $300. But if you get inside of that week, realizing that I have very little opportunity or chance of rescheduling time that's canceled within a week of the hearing date, then the penalties get more significant. If the parties in my situation cancel more than 3 work days out, then the cancellation fee might be something in the order of $500. But if they're waiting to within 2 or 3 work days of the actual scheduled hearing to settle a case, to cancel it, whatever they're going, as far as I'm concerned, they weren't necessarily operating in good faith in terms of being fair with me as an arbitrator. And in that case, I would impose a hearing cancellation penalty that would be equal to 1 day of hearing or my per diem salary, and that could be significant. And certainly with that type of cancellation fee or penalties based upon the proximity of the hearing, I think that the parties get the message that they need to negotiate in good faith, cancel in a sufficient time that they aren't penalizing the arbitrator because of their negligence or slothfulness. An additional topic that I would like to talk about at this point is the situation which occurs where parties will strike or blacklist an arbitrator, and this happens. One thing that I would suggest to you is that giving an impartial decision will not always make the parties like you. Disgruntled parties or their representatives may share their displeasure with their colleagues or business partners and work to get an arbitrator who has become the object of their anger or ire blacklisted. And by blacklisted, I mean they will badmouth the arbitrator or tell their colleagues something about the arbitrator which is adverse or negative, with the objective of penalizing the arbitrator by preventing that arbitrator from getting any future appointments or business with parties other than themselves. And that happens to a considerable degree. One thing you will see is that parties and their advocates are very nervous about who will be the arbitrator that's selected to hear cases that they present, and part of that nervousness or skittishness about arbitrators becomes very significant, especially when you're dealing with newer arbitrators or arbitrators who are not necessarily like the parties. And by that I mean arbitrators that the parties may already have a predisposition to believe are not necessarily going to be fair or the best arbitrators, and that particular group would include minorities and females. So minorities and females are certainly prime targets for being blacklisted or stricken from the panels that are suggested to parties. Now, when I say strike, the process of course is that a referring association, whether it be the American Arbitration Association or FINRA or whoever, would present a list of names of potential arbitrators, and if the party for whatever reason didn't want Joe or Mary or Sue, they would just strike that particular recommended arbitrator from the list of possible arbitrators for their case. And once the arbitrator is stricken or has been striked, then that arbitrator is no longer considered for appointment to that particular case. The rub occurs inasmuch as some associations will look at arbitrators who either get routinely stricken or who get negative feedback from parties in an adverse or suspect way, and it's not uncommon if arbitrators are infrequently selected for associations to let those arbitrators know that they're not going to continue to keep them on the association panels. In other words, if arbitrators are stricken too often or if it appears they're being blacklisted, then the associations will in effect fire those arbitrators from their association panel rosters. Given the fact that there is this systemic problem or bias which arbitrators are aware of, that they can get blacklisted, they can get stricken, quite often that type of adverse result occurs as a result of a party being unhappy with a decision that an arbitrator has written for someone in the past. And so the issue arises and subconsciously is on the mind of many arbitrators about how should I write my decisions. It's not just necessarily a question of who wins and who loses, but it's a question of what should I say, with the end in sight of avoiding the situation where you will be blacklisted. And so the arbitrator sometimes will ask himself after the conclusion of a contested case hearing or an arbitration hearing, should an arbitrator write an arbitration decision which throws a bone to the losing party in an arbitration case merely to avoid being unfairly stricken or blacklisted? Another question which will come up is, should an arbitrator's decision only address issues necessary to decide the case, or should the decision attempt to address all of the significant issues the parties have raised? An additional question related to the writing of the decision is brought up in terms of, should concerns about not getting future work affect either the tone or the content of a case decision? Now, a few comments here. Let's start with the issue of what should be in the decision. Should it address only issues which are absolutely essential for decision of the case, or should the arbitrator attempt to go beyond the first threshold issue and deal with some of the issues which the parties have raised? And quite often the parties are the ones who have raised these issues either in their charge or complaint or answer. There are differing opinions on this. Quite often in the courts you will see contested cases on appeal or whatever that go up, and a number of issues are raised which the parties think are very important, but the courts will dispose of those cases or the appeals by only looking at what they call a threshold issue. In other words, once I decide X, there's no need for me to decide whether there should be a Y and a Z. And that can be especially frustrating for parties, because sometimes it's not just a question of who wins and who loses. Sometimes it's a question of, well, what are the rules going to be in our relationship in the future? And this is perhaps particularly important in the labor arbitration setting, because as we all know, in labor it's not just who wins and who loses. The decisions are written with the end in sight of maintaining a peaceful, interactive relationship between the parties going into the future. A union and employer, they have to get along and deal with other concerns in the future besides the ones which are most obviously raised in the grievance which goes to an arbitration before me as an arbitrator. So sometimes the parties want the arbitrator to address the issues which they raise, because that may help them avoid future arbitrations, because they kind of learn what the interpretation of a contract provision is going to be from the perspective of a neutral, and that will allow them to avoid relitigating those same issues and concerns in the future. So when writing a decision, sometimes the arbitrator has to ask himself, well, do they really want to know my opinion of X as well as Y and Z? And if so, do I run any risk by dealing with issues or disposing of issues that I don't have to address in order to settle this particular case? And if the arbitrator is writing a decision to avoid being blacklisted, again, it cuts both ways, but there is an inherent pressure on the arbitrator perhaps not to deal with issues that you don't have to deal with, because you may be putting something out there that would cause someone to be particularly upset with you, and that could impact on your use in the future. Of course, the other side of that coin is the parties may not want to use you in the future in any case, because they were hoping and expecting that you would deal with the issues Y and Z anyway, and you ignored those issues, and they don't feel they got their money's worth. And of course, there's always a concern about the tone of a case decision, and it kind of goes to throwing a bone. And that can really be a sensitive issue that every arbitrator has to look at in terms of, first of all, their own attitude, their own style of writing, and secondly, the concern about, do I want to say too much, or do I want to say it in a way that would potentially impact on me adversely financially in the future. Well, they didn't like my decision. As I've kind of indicated, even when a party wins in a case, there's no guarantee that they're going to be pleased with your decision. And sometimes you'll find a situation as an arbitrator where the parties will turn the anger that they had previously directed at the adverse party towards you as the arbitrator. They're not happy with the decision, they're not happy with you, and suddenly you become even a worse guy than the opposition party had been during the hearing process itself. I had this type of situation arise in a case that I looked at a few years ago. It was a case that I handled for the Michigan Employment Relations Commission on a fact-finding basis, and I'm still on the Michigan Employment Relations Commission panel of arbitrators. I do grievance arbitrations, although I don't do fact-finding matters at this point in time because of some conflicts that have developed my retirement from the state of Michigan sometime before. But I want to use this particular case as an example to show you that writing a decision slanted toward one party or the other isn't necessarily going to make them like you. And in this particular Merck case that I'm recalling, it involved a school district and 3 of the education association unions that were attempting to negotiate contracts. And in the state of Michigan, as is true in many states, public employees and teachers can't supposedly go out on strike, and so the resolution of disputes, especially economic issue disputes, will go to first mediation. They'll try to negotiate a resolution. If that doesn't work, then it'll go to fact-finding, and the fact-finder will essentially do a hearing, will listen to the sides of both cases, and will make a decision as to what the fact-finder recommends in terms of what the fact-finder thinks that any ultimate contract should look at, and the fact-finder will essentially write a decision or opinion justifying the recommendations that the fact-finder makes. And that's the situation I was in with this particular school district and the 3 unions that were all involved in this conjoined hearing process. And after fact-finding, if the parties receive this decision or report from the fact-finder, they're supposed to go back and attempt to negotiate between themselves the resolution of their dispute, and essentially with the opportunity to see how a neutral looks at their particular case, the economic aspects of it, their positions. Quite often that would hopefully have the result of allowing the parties to, at that point in time, reach a negotiated contract or resolution of their dispute. And if that doesn't happen, since you can't go to strike, then you're going to get a binding decision from the Employment Relations Commission following a review of the record and possibly another hearing. So in that particular environment, I had a fact-finding hearing that lasted, and is very educational and informative for me. It occurred in a situation where there seemed to be quite a bit of animus between the parties, which is also indicated by the fact they hadn't been able to reach an agreement or settlement on these economic issues, and there was a lot of suspicion. But following the issuance of my fact-finding decision, which ended up being a decision or opinion of approximately 100 pages, the unions and the school district went back and they were able to do what they hadn't been able to do before. They, in fact, came to a negotiated settlement of the case and entered into a new set of contracts or collective bargaining agreements which dealt with some rather sticky issues. So from my perspective, I regarded that particular fact-finding assignment and my report as being a great success. in that particular report or decision, because of the realities of the economic situation and the positions of the parties, I had in fact written the decision and found in favor of the positions which had been advanced primarily by the school district. It was one of those situations where there just wasn't money there to accommodate some of the goals and desires of the unions. And after looking at the economic data and the witness testimony, including testimony from actuaries and health insurance consultants, I made my report and said basically I would recommend this happen, this happen, this happen. I don't see this being able to happen. Now, I wrote it in a tone that was sympathetic to the perspective or points that had been raised by the unions, but my job was not to provide equity. My job was to provide an interpretation of the environment which was realistic. It was more of a law type of approach based on my understanding of the facts, and I did that. So if anything, I would have suspected that the unions might not have been happy with the outcome and recommendations in my decision. Several months later, after this matter had been successfully settled by the parties, I was surprised to find from the executive director of the Employment Relations Commission that the school district had written a rather scathing letter to the commission about me, indicating they would never use me again in any of the cases they had. And I was surprised because they had essentially won on almost every significant point. But it kind of goes to show that either they didn't like the tone of my decision and report, perhaps they thought I wasn't abusive enough of the unions, or perhaps they were just so full of anger because of this very contentious period that they had just had with the unions that they turned their anger toward me. But in any case, they didn't like my decision. And so the bottom line is that sometimes, no matter how you write those decisions, one or maybe both or all of the parties aren't going to like your decision. Well, that concludes the presentation that I'm giving at this point for part 2 of this issue analysis of issues that are faced by arbitrators. I've already placed online part 1, which dealt with control of the hearing process, role of the arbitrator, and dealing with bias and conflicts of interest. In this part, we dealt with the issues of when the arbitrator gets sued, and also some of the issues that arise from business and operation considerations for arbitrators. The next and third segment of this video presentation, and it's also the last segment of this presentation, in part 3 deals with the issues of disclosure and also the issue of the impact of race and ethnicity considerations in arbitration. And I hope that you have enjoyed and that I've given you some things to think about. I look forward to receiving your comments and feedback. I also hope that you will take time and be interested to look at part 3, which deals with these disclosure issues and with the impact of race and ethnicity in arbitration. I think that those are particularly interesting and meaty topics, and I hope that you come back to study those and talk about those with me. I would just indicate that any of these 3 segments of the presentation should be available to you as videos from Black Gold Associates. These are made available to you. You can either go to the website resource page for Black Gold Associates and Spence and Associates, which I've indicated here. I'm also making these Black Gold videos available to you for viewing on YouTube, and if you go to YouTube you can find them as published by Minority ADR. Again, I'm Howard T. Spence. I thank you for taking the time to come and look with me at these particular issues that relate to problems that arbitrators face in the hearing process and in other aspects of the profession.